Great.
Hello, and welcome to Find My Law Tutor. We're here today with Professor Raul Sabado. He is a private criminal attorney and family law attorney in Claremont, California, and he is also a trial advocacy professor at Cal State University. Thank you so much for being here, Professor Sabado.
Oh, you're welcome. Thank you very much for inviting me.
Students, today we're going to talk a little bit about evidence. Evidence is a commonly tested subject on the bar examination, and we're going to talk a little bit about evidence essay questions. Now, Professor Sabado, what's an area of evidence that students have a particularly hard time with?
I'd say that hearsay is a common area of problems for students on the bar exam.
And why is hearsay a common problem?
Well, it's a complicated rule of law, and on top of that, sometimes it's hard to identify when there is a hearsay problem.
What is a good tip that you have for students on how to identify hearsay?
Well, I tell students that they should put themselves in the shoes of the trial lawyer in a particular hypothetical. In a particular hypothetical, there's often a witness who is not present in court that a trial lawyer would actually want to question in court. For example, consider this hypothetical. Walter witnesses on the stand, and the lawyer is asking Walter witness some questions, and Walter witness says things like, "Well, I heard Dave say the defendant shot the victim. I heard Dave say the defendant shot the victim." Well, naturally, a lawyer in the shoes of, or a lawyer in that hypothetical would want to ask Dave questions. They'd want to ask Dave questions like, Dave, how far were you when you saw the defendant shoot victim? Or, Dave, isn't it true that you've lied in court before? In other words, isn't it true that you've committed perjury in court before? These are all good questions you'd want to ask Dave. But the hypothetical tells you that Dave is not in court. It's actually Walter who's in court. And so you can't get at Dave and question Dave. If you have a hypothetical like that, where there's a witness not in court that you would want to question, that is a good sign that you have a hearsay problem.
Okay, not a witness in court, but you'd want to question them.
That's right.
Thank you. Now, what would you say is a commonly misunderstood hearsay exception?
Well, a common misunderstood hearsay exception is admission by a party opponent. And the reason that that's a commonly misunderstood hearsay exception is because the name is inherently misleading. First of all, the rule for admission by a party opponent requires that the out-of-court statement need only be a statement. It need not be an admission of guilt. It need not be against anyone's particular interests. It could even be in the speaker's interest. And so it's important to remember that admission by party opponent can be any statement made by a party opponent.
Does it often get confused with any other hearsay exception?
All right, naturally. Admission by party opponent sounds sort of like declaration against interest, another hearsay, a common hearsay exception. But in the declaration against interest, the statement literally need be against the person who's speaking his or her particular interest. But again, the admission by a party opponent needs to just be a statement in anyone's interest or against anyone's interest. Doesn't matter.
Okay, so a student should definitely remember that there are two hearsay exceptions that they should parse out. Maybe.
Right. I agree with that. That's true.
Okay, and there's a statement by the party opponent and potentially also a declaration against interest exception.
Right. That would be one good way to deal with that confusing type hearsay exception situation.
Thank you so much, Professor Sabado, for giving us your tips on evidence. Students, we hope that that helps you out in your evidence essay questions. Good luck from Find My Law Tutor.